court has given an executive branch official the opportunity to comply with an order and given them an opportunity to explain themselves, and that we still don't see compliance, the court can make findings that the official is violating clearly established law.
It's the Lawfare Podcast. I'm Alan Rozenshtein, Associate Professor of Law at the University of Minnesota and Research Director at Lawfare, with David Noll, Professor of Law at Rutgers Law School.
But if you dig into the statute that says what the marshals are supposed to do, enforcing legal process, right, is still the primary duty of the Marshals Service. So the marshals exist in order to carry out process of the United States, which of course includes enforcement of court orders.
I talked with David about his new Lawfare Research paper, Civil Contempt Against a Defiant Executive. We discussed his argument against the common assumption that the courts are ultimately powerless when faced with a non-compliant executive branch. David explained the powerful tools they can use to compel compliance, from levying personal fines to appointing their own deputies to enforce court orders.
So your paper challenges a view that I think has become quite common, and perhaps depressingly so, and that's that the judiciary is essentially a paper tiger if a president simply decides to defy his orders. So tell me more about this conventional wisdom that your paper is reacting to, and maybe also why do you think this honestly very depressing view has become so prevalent, at least, among people like us who think and write about the law?
So, sort of one of the most notable developments of the second Trump administration is this posture of open defiance of the courts. And you see it, sort of most visibly in the Abrego Garcia case, where after Judge Boasberg in D.C. ordered DHS to, quote unquote, turn around the planes that contained deportees that the administration was sending to El Salvador under the Alien Enemies Act, there was a frenzied discussion within the White House. And according to reporting, Stephen Miller made the call to ignore the judge because the planes were over international waters. And on his view of the law, there was nothing the court could do about that. So we're seeing defiance of the courts in a way that we didn't even really see during the first Trump administration. And that it takes us to a question about the legal process that in law schools and in thinking about the law, we tend to take for granted, which is how are these judgments, how are these orders actually enforced? I teach the first year civil procedure class, and, we spend months going through how to file a lawsuit, how to defend against a lawsuit, the different moves in a court case and the process that a case goes through, and spend maybe 20 minutes on how judgments are enforced. It's just taken for granted that if a court has jurisdiction over the case and jurisdiction over the parties, then people will follow the court's orders. And of course, as we're seeing now, it's not always true outside the world of public law, but we're seeing now that when it comes to the president's relationship to the courts, instead of adopting the posture that the courts have jurisdiction to decide cases, and the president has to follow court orders, the president can say, well, whatever, that's just a piece of paper, right? The courts can say what they want. We're going to do what we want. And that takes us to the question of what next? What's going to happen if a court says, don't do X, and Stephen Miller decides, you know what, I actually kind of like doing X. So the broad label for that is the contempt process, right? There's a whole body of law and there's a whole set of legal practices about how courts respond when parties defy their orders. And way at the end of that process, I want to emphasize that, right? At the end of the contempt process, the ultimate tool that courts have in the U.S. In England, courts used to cut off arms and other parts of people's bodies as a way of securing compliance with their orders. But in the U.S., right, the ultimate tool that courts have is to order contemners, people who are defying the courts, to be arrested by the U.S. Marshals. And this takes us to that premise that keeps getting floated, that the courts are powerless. Contemners are arrested by the U.S. Marshals, and the Marshals are part of the executive branch. So the thinking is that because the president is at the top of the executive branch, and the executive branch is organized hierarchically, the president, if he doesn't want somebody that the courts have declared to be in contempt to be arrested, can just say, hey, don't arrest that guy. The courts are out of control. The courts have gone crazy. You need to follow my instructions because I'm your boss. You'll be fired if you actually carry out an order to arrest somebody. And so that prompts this fear that at the end of the day, because courts are reliant on an executive branch agency for enforcement of their orders, what the courts say doesn't really matter, and the executive has this, no pun intended, trump card to disregard their orders.
Okay, so one more piece of background before we get into the sort of meat of the argument. So say more about the contempt power, and in particular, civil versus criminal contempt, because your paper is very specifically about civil contempt. So just explain why.
Right. So contempt is this power that courts have to compel obedience with their orders, to maintain decorum in court, to punish disrespect of court authority. It's something that comes out of the common law tradition, right? It's not invented in the U.S. It's something that we inherit when we inherit the English legal system. And as you mentioned, it's divided between what's known as criminal contempt and civil contempt. So criminal contempt is what it sounds like. It's a crime, right? It views defiance of court orders as a criminal offense. When you're charged with criminal contempt, it looks in many ways like an ordinary criminal trial. You get notice of the charges. You get to see the evidence against you. Usually, the court will appoint a prosecutor to prosecute the government's case.
And to be clear, criminal contempt, it's not a common law crime, right? There's presumably a statute somewhere that Congress at some point enacted.
That's right. There's a federal statute which makes it an offense to commit criminal contempt. There's a debate in the literature about whether courts need that. There's some courts and some scholars who say that just the grant of judicial power in Article 3 gives the courts power to punish contempts, but it's never been litigated, right? Because we haven't had a situation where the executive branch has been so defiant towards the courts prior to this. So that's criminal contempt. The key thing about criminal contempt is that criminal contempts can be punished, or the criminal contempt process can still take place even if the order that was defied is vacated or reversed. So a lot of times you'll see a situation where, say, a district court will enter a preliminary injunction. And we're seeing this increasingly, right? The executive branch will defy it or will engage in activity that looks like defiance. And the lawyers will say, hey, what's going on, right? The court entered an order. Why aren't you following it? And appeals will be taking place. And maybe 6 months down the road or a year down the road, an appellate court says that actually that preliminary injunction wasn't entered properly, right? There was some procedural requirement that wasn't satisfied, or, we disagree with the district court's finding of facts or their view of the law. And so the order that forms the basis for the contempt is vacated. Criminal contempt doesn't care about that, right? Criminal contempt is about vindicating the court's authority. It is, right, it's backwards looking. It's about deterring people from defying court orders. And so, right, there's established precedent which holds that even if an injunction is later reversed, purposeful defiance of that can be a criminal contempt, right? It can, be equivalent to a crime which results in a criminal conviction. And so, right, so courts continue to have that power regardless of whatever happens to the underlying injunction. So, as you mentioned, this paper is about civil contempt. Why am I talking about civil contempt? Civil contempt is about securing compliance with court orders. And, right, because of that orientation, you need to have a valid order, right? If the order that's being defied is vacated or reversed, courts lose their power to bring civil contempt proceedings because there's no longer a valid order that the court can compel you to comply with. So I'm writing about civil contempt for the simple reason that civil contempts cannot be pardoned. And right, when you think about contempt of court in the context of conflicts between the executive branch and the judiciary, there's a very real concern that if criminal contempt proceedings are brought, the president will simply pardon the alleged contemners, and that will be that. Pardons aren't reviewable. There's nothing courts can do about it. So sort of the choice to focus on civil contempts in this paper is really born of necessity. It's civil contempt is the one tool that courts have that operates independently of the pardon power, and that courts can use to compel compliance with their orders without presidential interference.
Okay, so let's now get into the levels, basically, of what courts can do when they're dealing with executive branch contemners. So the first is a whole set of sanctions short of arrest. So just describe what those are and why you think that they are actually more meaningful and have more bite than I think is often viewed.
Yeah. So let's start before we even get to sort of true executive branch employees with the lawyers who appear on behalf of the executive branch in court, because they are very important players in all of this. Right? Whenever the administration has defied the courts, right, there are lawyers that go into court and either say, "Oh, Your Honor, right? Technically, we're in compliance with your order," or Dan Deacon and Leah Littman have a wonderful paper cataloging some of the ridiculous things that they've said to try and justify defiance of court orders. But they're kind of the buffer, right, between officials in the White House or officials in DHS or whatever agency we're talking about and the court. And because of that role as the buffer, they are some of the first actors that courts can impose discipline on, or that the courts can impose sanctions on. So that's going to take the form of things like litigation sanctions, right? If you don't tell the truth to a court, right? If you misrepresent the facts to a court, if you as an attorney don't provide information that's available to you that the court orders, there's a range of sanctions that can be imposed against attorneys that eventually lead up to either disqualification to practice in a particular case or disqualification from a court's bar to potentially referral to state licensing bodies, which could put your law license at risk. And the reason that I think these sanctions are important is that attorneys are ordinary people, right? They depend on their ability to practice law. Most attorneys who work for the government either want to continue representing the government or they want to go through the revolving door and take advantage of their government experience to represent corporations and make a lot of money. And in order to do that, you need a license to practice law. And most times, if somebody's going to retain you as an attorney, they don't want to see a disciplinary record of the court finding you in contempt of the court's orders. And so the courts haven't really explored this option yet, but there does seem to be a range of behavior that DOJ lawyers have engaged in that plausibly puts them within the territory of being disciplined by courts. And again, notice that, right, this is something that's completely internal to the courts, right? You don't, sort of attorney discipline doesn't depend on cooperation from the White House or cooperation from the DOJ, right? It's entirely something that happens within the courts, that happens within licensing bodies. So sort of the first pressure point that courts can push on, and I think it's a pretty powerful one, is holding attorneys to their legal and professional obligations to be truthful with the court and to comply with court orders.
Yeah, I just want to stay on that for a second because I think people often forget that lawyers are lawyers first and executive branch employees second. And while they do have ethical obligations as lawyers to zealously advocate for their client, they have to do so within the bounds of the legal profession. And that is a thing that pre-exists, whatever executive branch obligations they have. I mean, I'm curious to sort of ask the question version of this. I mean, have you seen situations in which the lawyers are experiencing an actual ethical dilemma between their obligations to zealous advocacy on the one hand to their client and also their obligations to be honest to the courts? Or is this not actually an ethical dilemma that they're experiencing? It's just a professional problem that their client is often dishonest.
Yeah, I think the clearest example we've seen of this involves the conflict between Emile Beauvais and the prosecutors in the Southern District of New York when the White House was demanding that the righteous prosecution of Eric Adams be dismissed, essentially as a quid pro quo for securing Adams' cooperation with ICE operations within New York City. There's sort of a very famous series of memos going back and forth between Main Justice and the SDNY, where Beauvais takes the position that because of Article 2, you essentially must do everything that the president says, and you're engaging in insubordination, and you're violating the Constitution if you're not prepared to sort of lay it all on the line for the president.
To be clear, I mean, all of that might be true in the sense that the president might have an Article 2 this or that, and this might be insubordination, but that doesn't actually get at the professional obligation question of the SDNY lawyers as lawyers rather than DOJ employees. I guess that's the point I'm trying to get at, if that's a fair way to conceptualize this.
Yeah, I mean, I think sort of Main Justice's view would be that, I have an Article 2, and the Article 2 trumps whatever professional obligations you have as an attorney. But, that's just not the way the world works. Whatever your view of how to read Article 2, lawyers have professional duties. And those might not even be something that you conceive of as legal duties. That's, that might just be something that, this is what it is to practice law as somebody with integrity and somebody that clients want to hire. And, what you saw in that episode was a very clear conflict between, on the one hand, Daniel Sassoon's and other prosecutors' obligation to tell the truth, to pursue what they saw as righteous prosecutions, to not lie to the court, to not misrepresent the reasons that the department was taking actions to the court. And on the other hand, this edict coming down from Main Justice that says, Eric Adams is our buddy now. Let's make these charges go away so that he can use his powers as New York City mayor to make immigration enforcement easier within the city. And we saw where that ended, right? It's a really humiliating episode where all of the professional prosecutors, people that you would want to represent you because they're good at what they do and the courts take them seriously, end up dropping out of the case and end up ending their employment with the SDNY. And Emile has to, take the Amtrak or the Delta shuttle from DC to New York and appear in court, in district court as a senior DOJ employee to present the motion to drop the charges.
I think that's fair, but I mean, let's just push this a little bit because, of course, he did get on that Amtrak. He did appear. The charges were dropped, and as of when we're recording, he is a nominee to be a judge on the Third Circuit. So in the end, this all seemed to work out for the executive branch. I mean, one could look at this and say, actually, yeah, I mean, this caused some attorneys to resign, but that actually didn't get at the substantive question of whether or not the threat of professional sanction ultimately prevented the conduct, at the end of the day. So I'm curious how you see how the whole thing played out for your argument.
So this is, I think this is sort of what I'm encouraging folks to see is that these conflicts are going to be messier and have less of a clean resolution than we might expect. And I think sort of the Eric Adams episode is a really nice example of that because the career prosecutors, didn't get what they wanted as a first order matter, right? Their view certainly is that, Eric Adams deserved to go to trial and that a jury in the SDNY should make findings about his corruption and all of the things that they alleged in the indictments. Main Justice's view was that the indictment should be dismissed without prejudice so that it could, sort of hang over Eric Adams' head if he wasn't sufficiently enthusiastic when he went on Fox and Friends about ICE operations in New York City. And, we had this, this big conflict. We had dueling memos. We had, on the one hand, the president asserting his authority. On the other hand, career prosecutors saying, wait a second, we're lawyers. We can't lie to the court. And the resolution is kind of in between, right? The charges are dismissed with prejudice. And so just in terms of the concrete litigation outcomes, the White House did not get what it wanted, which was to be able to have this sword that it could hold above Eric Adams' head if he wasn't sufficiently enthusiastic about helping out ICE. At the same time, the career prosecutors didn't get what they wanted. And so really sort of, what the episode did is, it prevented both sides from getting what they really wanted. It was tremendously embarrassing to DOJ and Beauvais. I think, even if he somehow gets appointed to the Third Circuit, I think he'll always have an asterisk next to his name based on his willingness to serve as Trump's henchman. And so, the way I see it is that, here we're talking about an intra-executive branch conflict. But this is sort of the way that checks and balances are supposed to work, right? Checks and balances don't mean that everything is always going to be great and we're always going to have an executive that complies with the rule of law or what the law requires according to your best view of what the law requires. It means that these conflicts are going to be fought out and that you're going to see different sources of authority using their influence, using their power to fight for what they think is right. And then sort of the essence of a separation of power system is that when that happens, when you have people with conflicting incentives and different loyalties, that's good for the rule of law. That's good for liberty and the sort of the continued functioning of the constitutional system.
Okay, so that's the lawyers. Now let's talk about the government employees, because in your paper, you note that courts have a variety of ways of punishing noncompliance. They can deny qualified immunity. So just talk about how that works and also, how in particular the qualified immunity part would intersect with things like the Westfall Act.
Yeah, before qualified immunity, let me I do want to mention sort of the most basic tool that courts have available when it comes to executive branch employees that I think is going underused, which is just the ability to order people to testify. There is an incredible reluctance to come to court, get on the witness stand, swear to tell the truth and nothing but the truth. And we've seen several cases where the trigger for compliance with a court order wasn't these sort of nuclear sanctions that we talk about, including stripping qualified immunity and so forth, but was just a totally routine court order to testify. So we might say, why are executive branch officials so afraid to testify? Well, one risk is that they'll perjure themselves. And another risk is that an executive branch official appearing in court and testifying is something that acts as a focal point for the media. So, right, if you're the director of the Office of Personnel Management and you're testifying, that's going to be a hearing that attracts attention to what you're doing. And if there's one thing we know about the executive branch, it's that the media, which these days includes, sort of our balkanized social media environment, is sort of one of the main constraints and one of the main drivers of what they do. So there's that. But let's talk about qualified immunity. So we could assume that sort of somebody is not complying with an order to testify, or that they testify and the court isn't seeing the compliance with an order that it wants to see. The suggestion in the paper is that when that happens, right, when the court has given an executive branch official the opportunity to comply with an order and given them an opportunity to explain themselves and that we still don't see compliance, the court can make findings that the official is violating clearly established law.
The law here being the judge telling them, here's what the law is, please comply.
Exactly, right? Now, for people who aren't up on their qualified immunity doctrine, right, that phrase clearly established law or acting unreasonably in some formulations makes a difference because, right, that's the predicate for immunity, right? If you are a government official and you can say, look, the law was uncertain, I didn't really know what to do, or the facts were in flux. And so even if I violated the law, or even if I violated the Constitution, I made a reasonable mistake. Qualified immunity is an incredibly strong doctrine, which essentially blocks ordinary tort lawsuits where people who have been injured by constitutional violations seek compensation for that. So the suggestion is that when somebody is standing in defiance of a court order, one of the moves available to the court is to say, look, you're violating clearly established rights. Normally we would worry about, does this person have notice that what they're doing is illegal? Do they, have they been given a chance to come into compliance with law? When we're in this contempt posture, the court has said, look, this is what the law requires. And the court has issued an injunction directed at a specific official that says, do this because this is what the law requires. And what the paper argues is that in that circumstance, if you still don't see compliance, the court is justified in saying you are violating clearly established law, which has the effect of stripping your entitlement to qualified immunity and essentially putting you in the position of an ordinary person when it comes to tort litigation. So, the way this would play out is that, there would be sort of cascading proceedings. There would initially be contempt proceedings where an official's compliance with clearly established law was at issue, and the court would finally get fed up and say, look, you're violating clearly established law. What would happen after that is that there would be a second lawsuit filed seeking damages for the violations of constitutional rights. Those are ordinarily very difficult to win because of qualified immunity, but here would be in a posture where the original court, and would probably go to the same court under, depending on where the second lawsuit was filed, would say going into that tort lawsuit, there's no immunities at issue. Right? There's no qualified immunity at issue. And so the only question is, was there a constitutional violation, and what damages are the plaintiff entitled to by reason of that violation? So that is, this is getting kind of speculative because we just don't have a lot of litigation like that these days. Again, because until January 2025, there was a super strong norm of compliance with court orders. But that is, I think, something that even, fairly defiant executive branch officials should worry about, is sort of the prospect of being named a defendant in a tort lawsuit where they're not able to take advantage of qualified immunity and use that as a shield against the imposition of damages.
Why can't the government nevertheless come in under something like the Westfall Act, which, correct me if I'm wrong, allows the government to come in and replace basically itself as the defendant in a tort suit and just say, well, we just, fine, you think he doesn't have qualified immunity because he was mean to you, Your Honor, but we don't care. We're going to indemnify him anyway.
Right, yeah. So the Westfall Act is a very messy statute. I'm not going to try and cover all of the details of Westfall Act substitution here. The key limitation on the government's ability to substitute itself for a defendant under a Westfall Act is that the employee was acting within the scope of his duties. And so, there was some litigation surrounding this when, sort of Trump was involved in defamation trials.
This is the E. Jean Carroll.
Right, yeah. And at one point under Biden, DOJ made a determination that sort of the stuff that he was saying wasn't part of his official duties as president. And so the line of reasoning, and I really don't know where this would end up, but sort of the line of reasoning would be that when you are defying a valid injunction, which is to say an injunction where the court has jurisdiction over the case, and an injunction where the court has jurisdiction over the parties, that's just not the way that federal executive branch employees carry out their duties. And sort of in support of that argument, you would say, look at the history of sort of judicial executive relations up until January 2025, right? We just don't have a history of executive branch officials defying the courts, particularly when they've been given opportunity after opportunity to come into compliance with court orders. And so a court is going to be the one that makes the determination whether the government is entitled to substitute itself for an individual defendant named under the Westfall Act. And notice, sort of, if we hypothesize that a tort lawsuit is brought in the same court that found an official in contempt, this is going to be a court which has already found that an official is in contempt, an official is violating clearly established law. And so, I think there's a realistic possibility that, if you get the judge on the wrong side and the judge has built a record of noncompliance, that a court could say, look, this is really so extraordinary that, when you're hired as an official at the White House or at DHS, part of your job description is not to defy the courts. That's just not the way it works here.
What about private indemnification? So you can imagine a political campaign or a rich donor to the president, or in the case of someone like Trump, who is extremely wealthy at this point, the president himself, saying, you know what, fine, I understand you're going to be held in contempt. We're not going to be able to give you immunity, but I promise to just cut you a check for whatever the amount is.
Yeah. So, there's two pieces to this, a legal piece as well as a more practical, how would it actually work piece. The legal piece, Nick Perillo, who wrote a fantastic study on contempt in administrative law cases, has done the research. And his view is that as part of the contempt power, courts have the authority to prohibit indemnification of civil contempt fines. And so for the, sort of my advice for courts who find themselves in the position of trying to get executive branch officials to comply with their orders is, of course, to study Nick's article, because it's a wealth of information about sort of the practice of contempt and how contempt cases proceed, but sort of particularly his cites about, courts' authority to prohibit indemnification. And so just legally, right, a court can say, because what I'm after is compliance with my orders, and because indemnification can interfere with that, as part of my exercise of the contempt authority, I can enter an order which says this fine shall be paid personally by the contemptor. So if a court does that, and if that order, holds on appeal, then we're in a situation where, just as a legal matter, contempt fines can't be indemnified. And, so for people who haven't sort of seen how these contempt cases play out, I should probably mention sort of the standard order when a court is imposing fines. We'll say something like, for every day that you don't comply with the court's order, you're fined $500 or $1,000. So that's variant one, which, we're talking about, executive branch officials, particularly, if we're outside the highest policy-making levels, who may, just be earning a government salary and not really have the ability to pay fines that reach a couple $1,000s a month. But in sort of another kind of order that courts enter is a constantly escalating fine. So, right, if you don't comply with my order by Monday, then there's going to be a fine of $500. If it's not complied with by Wednesday, it goes up to $1,000. If it's not complied with by Friday, it goes up to $2,000, and it increases geometrically. So these fines can be quite substantial. And sort of even if we assume that there's going to be some kind of indemnification, say Trump, for example, Trump actually has to cut the check, right? He has to cover an official's costs that result from defying a court order. And particularly if we're in that second situation where fines are increasing, with each period of noncompliance, we're potentially in a situation where, sort of even to someone like Trump, you're talking real money. And right, sort of the ability to pay to not comply with the court's orders may be really unattractive if you're looking at millions or tens of millions of dollars of fines that result from prolonged noncompliance.
All right. So now let's turn to what happens if none of this works and you have to call in guys with guns.
Okay.
So let's talk about the marshals. So I think your paper is fabulous for so many reasons, but one of my favorite is that I think I finally understand who the marshals were, which I always had just like this very, and I suspect I'm not the only one who like has just this very vague sense. So who are the marshals and who do they work for?
Right. So I clerked in district court, and as you say, I remember the marshals as like very physically fit guys who would bring in defendants from custody for court appearances, and they were literally the muscle that was protecting the court.
That's so funny because when I clerked in a circuit court, and we did not. I don't remember if we had it even district court in the building, but the marshals that we had were very chill, somewhat elderly individuals who would like wave you through the metal detectors and like chat with you about the weather. It was I think it was like a different set of marshals at the courthouse where I worked. They were lovely people.
Well, no, there's actually a serious point here, which is that the Marshals Service is a large bureaucracy. It does a lot of stuff. It contains a lot of different people, and it performs a number of different functions. So, the very short version is that the marshals are the oldest federal police force, right? They're recognized in the first Judiciary Act from 1789. Sort of, back In the time of the first Judiciary Act, there was just one marshal who was a government employee for each judicial district. The marshal would then hire deputies who were private citizens who would help the marshal carry out his duties. The marshal's first statutory duty is to carry out, process of the courts, essentially to enforce court orders. And that's been the case going all the way back to when the marshals were first established. But as tends to happen in government, Congress has piled on duties to the Marshals Service and assigned them, lots of other stuff that they're supposed to do. So in the 19th century, the marshals do a lot of federal administration. So, they do some work administering land grants. They do some work administering the census. They're sort of an early administrative agency simply because they're the face of the federal government, particularly out west. And there's not, you don't have, government agencies with buildings set up and, customer service centers and all the stuff that we're accustomed to today. As we get closer to, to the present day, the marshals are assigned the responsibility for apprehending fugitives. So, see Tommy Lee Jones and, that side of the U.S. Marshals. They handle asset forfeitures. They handle, security, And so, the marshals are this, sort of this sprawling law enforcement bureaucracy where enforcement of court orders these days is only a part of what they do. They provide courthouse security. They do all this, this other kind of stuff for the federal government. But if you dig into the statute that says what the marshals are supposed to do, enforcing legal process, is still the primary duty of the Marshal Service. So the marshals exist in order to carry out process of the United States, which of course includes enforcement of court orders.
So how does then the chain of authority works, right? Because the marshals have two bosses. So just explain kind of just as at an org chart level, how the marshals answer up through the federal judiciary, but also answer up through the executive branch. And on the executive branch side, who appoints them, who fires them? I mean, how does that work? Because this nitty gritty, which almost never matters, becomes extremely important suddenly if you have a standoff between the courts and the executive branch.
Yeah. Okay. So there is there's a U.S. Marshal for every judicial district, and then there's a director of the Marshals Service and some administrative staff that work out of D.C. There's a general counsel, which will be very important if we ever get to the point where the courts and the president are fighting about enforcement of a contempt citation. So there's sort of the administrative part of the Marshal Service, but then, and people have criticized this because it's not the most efficient way of setting up a bureaucracy, but you continue to have a U.S. Marshal for every judicial district. The marshal is appointed by the president with the advice and consent of the Senate. The marshal appoints deputy marshals. Deputy marshals have some civil service protections. The details of this, I'm not actually completely sure of, but they're not directly removable by the president, so far as I understand. They seem to be. I'd welcome hearing from people who know more about the regs on this than I do, but they seem to be protected by the ordinary civil service protections, where there has to be cause to remove a deputy marshal from office, and you get a chance to go before the Merit Systems Protection Board to argue that you were improperly dismissed. And so, so we have this bureaucracy, which is spread out over all of the judicial districts. And if you dig into the statute governing the Marshal Service, it says their primary duty is to enforce the legal process of the courts. But then it says, and this is why people talk about the marshals having two bosses. It says the marshals shall operate, under the direction and control of the Attorney General. So, and this comes out of a Civil War era statute that first gave the Attorney General basically managerial authority over U.S. attorneys' offices and the marshals. So the idea is that the Attorney General has oversight authority, make sure that the marshals are paying their bills on time and hiring competent people and administering all those aspects of the business side of the Marshals Service. But then, the statute continues to talk about, what are the marshals supposed to do? And the first thing we know from Congress is marshals are supposed to enforce court process. So you're supposed to enforce court process within a structure where everything happens under the oversight of the Attorney General.
So what then do you think would happen, or what could happen? Because obviously there's a range of possibilities. If you have a situation where the marshal is getting, mommy and daddy are fighting, right? Like one boss is telling the marshal, hey, go arrest this guy because he's, in contempt. And the other guy is the president saying, yeah, but the guy you're trying to arrest is the attorney general or whatever, or just an executive branch official. And don't you dare do this because I will fire you or whatever the hell happens. So like what happens in that situation?
So everything is going to depend on the U.S. Marshal for the judicial district where a court enters an order for the arrest of an executive branch official. So say that we're in the District of Maryland, and in one of these immigration cases, the judges get fed up and say, look, I've given you opportunity after opportunity to comply with my orders. I've tried fining you. That didn't work for whatever reason. I've tried referring the attorneys for discipline. That didn't work. I've had it. So-and-so is responsible for defying my order. I'm ordering their arrest. So the first step is just there's the entry of an order to that effect. And so the court will write an order that says the U.S. Marshals Service is directed to bring so-and-so into custody. The court might issue this delightful old writ called a writ of bodily attachment, which is just what it sounds like.
That's good. I've never heard of that one. That's a good one. I think I heard that banned in college, writs of bodily attachment.
Yeah, there's a lot to unpack there. But it's, just sort of like, you might attach real property. This is, bring this person into court and hold them into custody. And that's directed to the Marshals Service. So the marshal for a district, say the marshal for the District of Maryland or, for DC or Virginia, Northern District of Virginia, whichever court is entering this order, they then have to decide what to do. So, one scenario is that the president just stays out of it. And that's an easy one because the marshals have a statutory duty to enforce court process. I imagine there would be some extremely delicate behind-the-scenes conversations to the effect of, look, the court has ordered that so-and-so be arrested. We don't feel great about it, but we have to bring him into custody. And then, we'll let the lawyers handle it and see if so-and-so can purge himself of contempt. The other possibility, which I think is much more likely, is that the White House would go to war with the courts. Every week the White House is putting out inflammatory messaging about how the courts are out of control, only when it loses, of course. And something has to be done about rogue district court judges. And so I think the more likely scenario is that were a court to issue an order for the arrest of an executive branch official, you would see Trump or one of his surrogates say, no, we're not going to comply with this. Right? It's our executive branch. It's my Article 2. And, if the marshal chooses to abide by this order, they're out of a job and, many, many worse things will happen to them because they'll probably get doxxed. Their family will be harassed and threatened. And, who knows what else will happen to the marshal. So put yourselves in the position of a marshal, right? The marshal for a district is the one who's responsible for, picking the deputy, right? Assigning somebody to carry out this order. If mom and dad are fighting, that person needs to ask themselves, what is their legal duty? And they'll probably get advice from the general counsel to the Marshals Service. In the paper, I run through, as quickly as I can, sort of the legal arguments for why the president would claim authority to have the power to call off the marshals. In my view, they all border on the frivolous. There's not really a strong argument that the president has authority to call off the marshals, but the marshal, right, will surely know that if he or she orders the court's order to be carried out, they're probably going to lose their job. At a minimum, life is going to suck because, right, a whole bunch of people within the Marshals Service and a whole bunch of people in the White House and Fox News and Twitter and that entire universe is going to be very displeased with what's going on. So, I'm a law professor. Obviously, I don't have the answer to how a marshal is going to respond in that situation. I think it's probably very dependent on sort of the politics of a particular case and how many opportunities the executive branch has been given to come into compliance with a court order. One thing that I'd note, sort of after spending some time with the history of the Marshals Service, and this goes back to Tommy Lee Jones, there is this, this almost macho ethos of we are the marshals, and we're not here to enforce court orders. Our whole thing is that people are defying the courts and people are defying the Constitution, and we're the muscle that that brings them to account.
It's like the platonic ideal of the lawman, right?
Yeah,
we really are.
If you go to the Marshals website, and go into their historical reading room, they've got pictures of the Marshals helping to integrate the University of Mississippi, accompanying Ruby Bridge. This is, it's complicated because, law enforcement in general tends to have a lot of sympathy with the MAGA movement and a lot of sympathy for Trump. On the other hand, the Marshals, their whole shtick is enforcing difficult to enforce court orders. And so, you can imagine that playing out where they say, where a marshal sees this as a continuation of the righteous tradition of enforcing the Constitution and enforcing legal process against people who are committed to defying it, and in this case, defying the courts. So, that's the choice for the marshals. It's anybody's guess what a particular marshal is going to do. But, sort of what I hope comes across is that, to say that this is just is going to be an easy choice because the marshals, you have to submit budgets to Pam Bondi and, are under the supervisory authority of the Attorney General, is ignoring these other aspects of the Marshals' culture and all the other things that are going to be at play in a showdown between the Marshals Service and the executive, or a showdown between the courts and the executive. And so it's, sort of gaming out what the marshals are going to do is, I think a lot more complicated than, just saying, oh, the marshals are within the executive branch, end of story. The executive branch, at the end of the day can do whatever it wants in response to court orders.
AI policy debates these days move faster than DC tourists chasing shade in the middle of July. If you're struggling to keep up with AI law and regulation, Lawfare and the University of Texas School of Law have your back with a new podcast, Scaling Laws.
In the show, we dig into the questions that are keeping folks like Sam Altman awake, that are driving legislative policy and steering emerging tech law. I'm Noll and Rozenshtein, Lawfare's research director and a law professor at the University of Minnesota.
And I'm Kevin Frazier, the AI Innovation and Law Fellow at Texas Law and a senior editor at Lawfare.
We've lined up guests you won't want to miss, so find us on Apple, Spotify, YouTube, wherever you get your podcasts. Subscribe and don't miss what's next. Okay, so let's imagine that, unfortunately, the marshals cave. They go along with the executive branch. So now it's a really bad situation. But you argue that the courts still have sort of one lever to pull, and that is to appoint their own deputies. Basically, go out and just find someone. So just describe this deputization power, where it comes from. And there are a lot of historical precedents, but I want to focus on the one that you spent some time on, and that is one of the most famous cases, actually, in all of American history, Ex parte Merriman. Explain, just use that case to give sort of a kind of example of how this might work and what the historical precedent and in particular how Merriman ended up, how that changes your views of just how plausible any of this is.
Okay, so the marshals have said, look, we'd love to enforce your order, but I'm going to get fired if I do that. So the courts are stuck. The last part of the paper is trying to recover this historical tradition of courts appointing independent deputies or deputies that aren't part of the federal executive branch to enforce their orders. So this really, it comes out of looking at the way that the federal judiciary worked in the 19th century. sort of before we get into the modern era of the federal court. So remember at this time, sort of the federal government, sort of if we're dealing with, westward expansion, might consist of, say, a post office, a single district judge or a single circuit judge, a U.S. Marshal, and that's it. And they might all be, sort of in, some very tiny little federal building that is, that's rented from the general store in Nevada or Oregon or whatever have you. And so, right, in this earlier period of the federal courts, we have this tradition of the courts fairly routinely looking to other actors to enforce court orders. And that's totally born out of necessity. It's because we don't have a 6,000 person Marshals Service that can carry out the court's orders. So the first thing that I point out in the paper is that sort of the legal authorities that underpin courts' ability to appoint deputies and to enlist deputies were never taken off the books, right? So the courts, have authority under the All Writs Act. There's a provision of the Federal Rules of Civil Procedure that I get into that seems to contemplate the appointment of deputies. There are folks that have suggested that Article 3 gives courts the authority to appoint deputies to enforce their orders. We don't have a lot of experience with this because, again, prior to January 2025, the norm was executive branch compliance with court orders. But there's sort of this vestigial power to appoint deputies to carry out court process, even against the executive branch. Okay, so how might this work? That takes us back to Merryman, which is a conflict from the beginning of the Civil War. The short story is that there's a lot of Confederate activity in Baltimore. Baltimore is really important because D.C. is kind of an island in the middle of Confederate sympathizers, and Union supply lines and Union telegraph lines run through Baltimore. The Union Army goes into Baltimore. Lincoln issues an order to his generals to arrest Confederate sympathizers. He also says, by the way, you have the authority to suspend the writ of habeas corpus, right, which is the ancient common law writs that courts use to examine whether people are being detained lawfully. Merryman is detained by the Union Army. The Union Army gives him access to a lawyer, and he files a petition for habeas corpus before Roger Taney, who happens to be, there's a dispute about whether he's actually the circuit justice or whether he just has chambers in Baltimore, but he's the local district judge for Baltimore. And Taney issues a writ that says, right, at the time you would actually produce the prisoner so that you could figure out whether he should be detained. It says, produce Merryman on a writ of habeas corpus. The marshal goes right to the fort where Merryman's being held. It says, I have this writ. Please produce Merryman. The judge has ordered, and is given the thanks but no thanks, and so he returns to court empty-handed. Taney then issues another writ for the attachment of the Union general who refused to produce Merryman. That is not enforced. He goes back. And then we get this, the long opinion that everybody reads in law school where Taney is reacting to the fact that Merryman was not produced as the court has ordered. So there's two really important points in this episode sort of for thinking about present day conflicts. The first is that Taney sort of rather casually assumes that the marshal had authority to summon a posse comitatus to physically secure Merryman and bring him before the court so that the court could examine the lawfulness of his detention. He points to a provision in the First Judiciary Act that allows the marshal to summon a posse comitatus. And so sort of the suggestion is, and this is he doesn't even spend a lot of time on this in the opinion. It's just, it's the way that courts worked in the 19th century. He says, well, look, you could have summoned a posse and you could, this posse of ordinary, men at the time would have helped you, obtain Merryman. But then he does something which is sort of a remarkable exercise in realpolitik. He says, but obviously, if you summoned a posse, the posse would be going up against, the Union Army, which at the time was extremely well equipped, was organized. We're at the beginning of the Civil War. They had a lot more firepower. And so he says, look, given that the Union Army had the advantage in firepower, your duty to enforce the court's process is excused, right? Ordinarily, I would require you to enlist the assistance of private citizens to help carry out my orders. But, given that you're going to lose a battle, a standoff with the Union Army, your duty is excused. So, I think that that's the basic template for how one of these modern day conflicts will unfold. If we imagine the marshals standing down, a court does have legal authority to appoint private parties. It could be, I talk in the paper about special deputy marshals. There's apparently thousands of these people who have been deputized, who don't work for the Marshals Service, but have the authority to carry out arrests and do other marshals functions, who might be employees of other federal agencies. A court could appoint local law enforcement. So the court, I'm fairly confident, has legal authority to appoint deputies. But then the question becomes, what are they going to do, right? What shows up, or sort of what happens when one of these deputies show up at, the condo of some underling of Stephen Miller and says, you're required to come with me because the court has ordered your arrest.
Especially if the executive branch has sent the marshals to protect the underling, right? I mean, at some point you have a situation where you have executive branch, enforcement and private citizens shooting at each other. I mean, this is the nightmare scenario, right?
Yeah. I guess I should have said, even before the court appoints a deputy, we are so far into a constitutional crisis that, sort of the wheels are coming off the car in all kinds of unexpected ways. Complying with court orders is part of our legal culture. It follows from the judicial power in Article 3. It's just a basic aspect of constitutionalism in the United States. So when you start messing with your compliance with court orders, you're introducing uncertainty into the system in a way that I don't think anyone can really game out, because
we have bigger problems at this point, is what you're saying, than whether this or that marshal is doing this or that job.
Yeah, I mean, as an academic, I think about it, you want to talk to the guys who specialize in failed societies and in coups and in, sort of armed insurrections and stuff like that, because they're the ones who really have a read on this. So if the marshals are to define a court order, we're already in that world, right? Because law doesn't mean what we expect it to mean. And so one question is, right, if law is no longer a thing, do the marshals care that there are missives coming from the White House that say, do this or you'll be fired? They might say, law, right, this is all a joke, right? Like, this is, sort of like the order is falling apart. We're going to do what we think is right, or we're going to do what we think, best protects our office, or, what accords with our sense of justice. So, I mean, just to underscore, we are in a really bad, really chaotic place. But assuming the marshals continue to follow or directions from the White House or from the Attorney General, then you're in a situation where you might have, say, members of the DC police or members of the Maryland police who go to arrest an executive branch contender, and there's an attempt to interfere with that is being sort of orchestrated by the White House or orchestrated by the Attorney General. So, that is, as you say, that's a hot conflict, right? Because you have one group of people with guns saying that somebody must be brought into court. You have another group of people with guns saying that, the person should be insulated from court process. I don't know the answer to how that's going to play out, right? I can imagine sort of a court that acted very strategically and in a savvy way, doing all this fast enough that the White House was really caught flat-footed. Sort of think of an inversion, if you like, of the El Salvador rendition flights, where everything was organized ahead of time, and the courts didn't have an opportunity to review the legality of the flights before people were deported under the Alien Enemies Act. If the pieces fell into place, I could see, at least temporarily, an executive branch contender being brought into the custody of the courts. I can also see it going the other way, right? I can also see, federal law enforcement agencies that are sympathetic to Trump or sort of sympathetic to mass deportations rallying and, recreating a Merryman situation where it's practically impossible to get access to somebody that the court has ordered be brought into its custody. But sort of continuing with the theme of all of this being messier and weirder than people are giving it credit for, just think for a second about like how extraordinary that would be, right? You have sort of the deputy undersecretary for Homeland Security or whoever, subject to a court order, right? Not able to go anywhere without a bunch of SUVs, trailing him or her around, ensuring that they're being protected from court process. Even that's going to make it hard to do your job. Is going to, create a media spectacle, or to create this sort of extraordinary situation. And so again, we see sort of, even at the end of the day, if the courts can't, if the courts aren't going to win sort of a battle of guns, they do have this ability to escalate the situation. They have the ability to drag it out. And, sort of one of the things that I was trying to accomplish in this paper was sort of encouraging courts to see that. It's encouraging courts to say that, look, this isn't just up to the executive branch. You have tools that are available to you. Nobody wants to see a hot conflict. Nobody wants to see, different police forces in a standoff over whether a contender will be brought into court. But at the same time, it's a little funny to see people proceed on the assumption that the courts are totally powerless and the courts don't have any ability to continue the conflict and to escalate it.
So before we conclude, I want to zoom out for a second. The first thing I want to ask is what the role of the Supreme Court is in all of this, because we've been having this conversation largely at the district court level, right? Mm-hmm. You have a proceeding, you have a district court, the judge is pissed, and the judge then does a bunch of things, and that causes other things to happen. And I can easily imagine district court judges, getting very frustrated. I could even imagine a appellate court upholding some of these aggressive enforcement actions on the part of the district court. Mm-hmm. But at the end of the day, it's going to end up at the Supreme Court, certainly if this is a high-profile conflict. And, look, it's a 6-3 conservative Supreme Court. Now, I'm not such a legal realist that I just look at, the political party of the president that appointed the justice and say, okay, well, that's how it's going to go. And I think that you can look at the Supreme Court and you can see ways in which they have not just done that. You can also get the Supreme Court, and we're recording this a few days after the opinion in the Universal Injunctions case came out, and that's obviously, again, this is a very complicated opinion. There's a lot going on there, but you could look at that quickly and say, oh, it's yet another example of the 6 quote unquote Republican appointed judges ruling for the Trump administration against the 3 quote unquote Democrat appointed judges. So how confident are you that in a righteous case of trying to make a contemner actually do the right thing, the Supreme Court will ultimately back up the pissed off district court judge?
So I think what you're going to see is the Supreme Court trying to act as a mediator between district judges and the executive branch. And, sort of the proceedings around Abrego Garcia are a really nice example of that. Sort of we start with a district court order to, effectuate and facilitate his return to the United States. We get a bunch of arguments about, OMG, you're telling the executive how to conduct foreign affairs. That's beyond the power of a court. And so that gets watered down to an order to facilitate his return to the United States. But notice that was a 9-0 order. That was Clarence Thomas and, Neil Gorsuch and Sam Alito saying that there was an obligation on the part of the executive branch to comply with the district court order to facilitate Mr. Abrego Garcia's return. So, I think that the court conceives of itself wrongly, in my view, as the adults in the room. I think it sees district courts that are strongly asserting judicial power and trying to secure compliance with court orders. And I think sort of the posture the court takes is, we got to tap the brakes. We got to, be mindful of the role of different branches of government. And so, sort of the pattern I would expect to see is the court walking back, if not nullifying, a lot of the stuff that district courts are doing. At the same time, as you say, I think that even with this Supreme Court, and even in matters that affect executive power, law does matter. Right? A unanimous court could not stomach the idea of someone being rendered to indefinite detention in El Salvador, and issued, I think, was the sort of the strongest order that the court thought would have a chance of being complied with. And so, in my view, there's a lot of wisdom in district courts, and the Supreme Court should be a lot more deferential towards judges who are actually hearing evidence. But even if you take the Supreme Court's self-conception of itself as the adults in the room who have to walk back some of what district courts are doing, I don't think it's a foregone conclusion that they will simply go along with whatever the executive branch says. And part of that, just to close the loop on this stuff, relates to the defiance of professional norms that we've seen in this district court litigation, right? There have been misrepresentations to courts. There have been failures to comply with court orders. Some of that, the SG is able to spin as district courts being overly aggressive, but some of it is just completely lawless. And, the justices and their clerks look at the records in these cases and they know what's happening in lower courts. And, as members of the legal profession, as the head of Article 3, I would hope that they feel some obligation to vindicating judicial authority and to maintaining a separation of powers system rather than just going along with the executive.
So let's close on this question. So I could not decide whether your article was making me more optimistic or less optimistic about the rule of law.
That's what I look for in scholarship, just people.
because on the one hand, it's an extremely persuasive case for the existence of a whole set of remedies that, while not 100% effective, are definitely more effective than the kind of doomerism that you get, or that I think has recently been expressed in our profession. On the other hand, the fact that you had to write this paper is not a good thing, right? The fact that someone had to sit down and be like, well, I guess the marshals, and even if the marshals don't do this, we can get some private guys with guns. And so I'm just curious, and I'll just ask for your just personal sense, right? Having written this paper, having spent the last hour and a half talking about it, are you feeling more optimistic or less optimistic about the rule of law in this country?
Jack Rakove put out a piece in Washington Monthly, which I really appreciated, which was sort of making the case that we've moved beyond constitutional crisis to a form of constitutional failure. And I thought a lot of the stuff that he said was quite persuasive, just sort of looking at how the basic checks and balances of the constitutional system are supposed to function. I guess that's my general orientation looking at these kinds of things. But sort of the optimistic thing that I'll say is that to say that we're in a state of constitutional failure, I think isn't the end of the rule of law. I'm, among people who think that, we weren't really operating under something that deserved to be called a democracy until the 1960s. And yet there was rule of law, right? There was some legal orders that were followed, right? Sort of the practice of conducting government according to constitutional principles was taken seriously, even as it was seriously challenged. And so I guess where I see us is sort of in this moment of extreme tension where a lot of the system isn't working the way it's supposed to be working, but clearly, I can go to Whole Foods and, my credit card works and, we're not a failed state in that sense. And I think sort of, and this has really sort of been a tough thing for myself as a law professor and as a legal scholar, is because we're used to the assumption that we're working within a sort of a fully functional system. And people who study sort of criminal justice or, sort of transitional democracies will tell you, well, that's not really the case, right? We're always somewhere between full rule of law and complete societal breakdown. And in my view, we're in one of those spaces now, right? Features of the constitutional system are not working the way that they're supposed to. But at the same time, there's still space for legal arguments. It's still, seen as subversive not to comply with court orders. The Constitution, due process, separation of powers, these concepts continue to have just a really strong, intuitive moral force. And so, I think sort of the challenge for lawyers and for courts is both to be realistic about where we're at, but then to understand how legal process and the moves that are available to courts and lawyers can move us in the right direction towards a federal government that is, more firmly operating according to the rule of law.
I think that's a good place to end. Thank you, David, for the excellent paper and for this great discussion.
Oh, likewise. Thanks for the discussion.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter at our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. Look out for our other podcasts, including Rational Security, Allies, The Aftermath, and Escalation, our latest Lawfare Presents podcast series about the war in Ukraine. Check out our written work at lawfaremedia.org. This podcast is edited by Jen Patya. Our theme song is from Alibi Music. As always, thanks for listening.